Whenever y'all are ready.
Good morning, Your Honors. May it please the Court, my name is Christina Pereira Duda, and I represent appellant Kozma Investimentos LTDA. Before I begin, Your Honor, Your Honors, I'd like to reserve 5 minutes of my time for rebuttal.
Okay.
By way of very brief background, an arbitration award was entered in Brazil in favor of appellant in the amount of $14 million plus interest. Appellees filed a declaratory judgment action with the Court of Justice of Sao Paulo, Brazil, seeking to invalidate the arbitration award. The Brazilian court dismissed appellee's action, upholding the validity of the arbitration award. An appellant then sought recognition of that Brazilian court order in the Circuit Court of Collier County. And at the hearing, the Circuit Court denied recognition of the Brazilian court order, which denial appellant now appeals. And Your Honors, we're here today to ask that the order to present that the order entered by the Brazilian court is entitled to recognition as a foreign judgment because it awards recovery of a sum of money and is final, conclusive, and enforceable where rendered. And the decisions by the Second Circuit in the Sea Transport 2 case and the Northern District of Illinois, the District Court for the Northern District of Illinois, and the National Aluminum case, which are both cited in our briefs, are not only instructive, they're nearly factually identical to the issues here and moreover dispel many of appellee's arguments against recognition. And I'd like to address two primary arguments that appellees raise and why those arguments are misplaced. And the first is that the judgment ostensibly does not award a specific sum of money and courts cannot look to any other document other than the judgment itself. And the second argument being that the judgment fails to effect a writ of execution. As to the first argument regarding a specific sum of money, all four of the cases that appellees rely on for the argument of a specific sum of money as a condition precedent for recognition are distinguishable for one very notable reason. In all of those cases, it was only the question of liability or entitlement that had been determined by the foreign judgment, and the amount of damages was completely undetermined and required or contingent upon some future event or act happening in order to quantify those damages. So for example, NICOR out of the Southern District of Florida, which was one of the primary cases that appellees rely on, there the sentence determining liability and entitlement was decided without any quantification of damages, and only after that sentence was entered did the process of computing damages even begin as per Dominican law. And it was only that sentence determining liability and entitlement which the party had sought recognition of. And the NICOR court heavily relies on Bianchi out of the First District Appellate Court of Illinois, and that court's denial of recognition for the position that a judgment had to have a specific sum of money. But the Bianchi decision itself was specifically distinguished by the District Court for the Northern District of Illinois in National Aluminum on the grounds that there, in Bianchi, the court refused to recognize recognition not because it required calculation or didn't state a specific sum of money, but because calculation was simply impossible. And the Bianchi court dealt with back wages and where underlying employment contract was void and there was no reinstatement of the employment, there was no way to quantify the amount of damages.
Let's say we agree with you that a specific sum is not required.
Mm-hmm.
Looking at the face of this judgment, why should we not conclude that the specific sum is 15% of roughly 2,300, I guess, Brazilian dollars?
Well, excuse me.
Because that's the only number that shows up in the judgment here.
Well, respectfully, the Brazilian court order specifically references the sum of $14 million a few times. At page 123 of the record at paragraph 5, where it lays out what the appellees were arguing in that case that defendant...
But what it says is, I hereby dismiss the present action and render judgment against the plaintiffs for payment of court costs and attorney's fees of 15% of the value of the action. The legal fee for appeal is R2283.78. That is by the plain language of the judgment. And so why is it that we should look behind the face of this judgment and say, oh no, even though this is what it says, what it's actually doing is it's affirming this $14 million award and incorporating it by reference into the judgment. And so now what we have is a judgment of the Brazilian court in your favor of $14 million, because that's the part that I keep getting hung up on.
Sure, and I have two responses to that. First, in Section 1, where the Brazilian court starts issuing its order, the court states plaintiffs, and meaning here the appellees, argue that the award exceeds the claim since deciding the motion for declaratory judgment, and continues on, resulted in an adverse award to return the exclusivity fee in the amount of $14 million US dollars. On merit, plaintiffs are not right. The award issued did not exceed the scope of the arbitration tribunal, which decided justly on the termination of the contract and the return of the exclusivity fee. So the Brazilian court is saying...
Right, what this is saying is you've got an enforceable arbitration decision, and so based on this judgment saying you have an enforceable arbitration decision, why isn't your remedy to then go into federal court and seek enforcement of the arbitration decision under the New York Convention?
Well, that would be if we were seeking enforcement of the arbitration decision, but here it's appellant's position that there is now an order of a governmental entity out of Brazil upholding the validity of the arbitration award, and that's now a foreign country judgment. And to further answer the question as to relying on an external document, the District Court for the Northern District of Illinois specifically rejected the argument, in National Aluminum, specifically rejected the argument that you can't turn to a different document. So at footnote 5, at page 999 of that opinion, the court notes, Peake argues that Bianchi also stands for the proposition that the money amount must be stated in the text of the judgment and cannot be determined on the basis of another document. And then goes on to, with citations, this is also incorrect. Bianchi held that the document to be enforced must be a judgment, not that other documents could not be considered. And the case that appellees here rely on, NICOR, relied heavily on the Bianchi decision, which the Northern District of Illinois has specifically distinguished and rejected some of those arguments. So there is case law saying you can refer to another document, and quite frankly, I wasn't able to find anywhere in the language of Florida's judgment that specifically says that there is a prohibition against referring to another document.
Well, that's the thing. I mean, we're to some degree in Florida, we're writing on a blank slate here. And it makes me nervous when you're dealing with, we've got orders from other courts, they, different countries, they use different languages. These are all based on translations. To now start saying, well, you've got to go through the whole document to find out what they really meant, and now we're not just interpreting a legal document, we're interpreting a legal document that's been translated from the original language. What happens when we make a mistake with that, as opposed to looking at this, and when the court is telling us, here is my judgment, and my judgment is you get 15% of, roughly 2,300 Brazilian dollars. How far why should we go behind that? Why should we second guess that and say, no, that's not really what your judgment is. If you go back to this paragraph in here, you said this too. That's where I start getting really uncomfortable, and so I'm wondering, what's the justification for that?
And I understand the court's concern, and as evidenced by the fact that there isn't much case law out there on this topic. But I would point the court to the committee notes to the Model Act, to the section where foreign country judgment is defined, and it states that the foreign country judgment need not, and this is committee note 3, that the foreign country judgment need not take a particular form, and more importantly, that a judgment of a foreign court confirming or setting aside an arbitral award would be covered under the Model Act.
But it didn't do that. It dismissed the challenge to it, but at no point did it didn't say we confirm or affirm the award.
But by dismissing the challenge to the award, and the challenge being the validity of the award, by dismissing the challenge, it upheld the validity of that award. And to allow...
Is that explicit under Brazilian law? I mean, that's what we can assume based on how we handle things.
Well, under Brazilian law, arbitration awards are self-enforcing. So to require the Brazilian court to say this arbitration award is now enforceable, go forth, would render that Brazilian law superfluous that arbitration awards are self-enforcing in the first place. So I don't know that Brazilian court would make that statement. And to require the magic words of, I award you $14 million when the Brazilian court's order upholds the validity of it, is then putting form over substance, where it's ignoring the practical and legal effects of the order, upholding the validity of that award. And then turning to the argument that appellees make regarding that the judgment fails to effect a writ of execution, again, as I just mentioned, because the Brazilian law provides that arbitration awards are self-enforcing, the court was not required to say, you may now execute on this arbitration award. It upheld the validity of it, and therefore appellants were able to proceed on that court order upholding the validity. And I know appellees or opposing counsel will raise the argument that in the, I believe it was the sea transport case, there was a conveyance or exequatur in the French arbitration award, and for the reasons I just mentioned, that would not be required in this case. So any distinguishing factor that would pose is negligible in this case. And so, Your Honors, it's appellant's position that it was error and unreasonable to read into Florida's Foreign Judgment Recognition Act requirements or conditions that simply don't exist in the plain language, specifically that there is a specific sum of money and that you cannot refer to another document, because as the cases of Sea Transport and National Aluminum out of the 2nd District and out of the Northern District of Illinois, respectively, show, those cases are almost entirely on fours with this fact pattern presented in the court below. And like cases should reach like results. So if Your Honors have any other questions.
No, thank you.
Thank you.
Good morning, and may it please the court. Jose Ferrer and Desiree Fernandez on behalf of the Dudas, who were the defendants below. I want to get into the substance of the argument, but Judge, I wanted to address your question about the New York Convention and why it is that they're not enforcing the award directly. There is a parallel federal action. We allude to that in a footnote. That federal court is watching what is happening here because it's determined that what this court does will guide its ruling in that case. But the reason that they're not proceeding under the New York Convention directly under the award is because they blew the statute of limitations. That's really the reason why we're having to go through these gymnastics to try to get this order, which is not a judgment, confirmed as if it was a judgment. The issue really is, does this Brazilian order constitute a final, conclusive, and enforceable money judgment that can be enforced in Florida? And we believe that affirmance is required for two reasons. One, it isn't a judgment, and certainly not a judgment for the $14 million that they seek. And two, the order doesn't award the specific sum of money. And I'll get into both of those in just a moment, but I wanted to start by discussing really what the Act says is necessary in order for a judgment to be enforceable. In order to be enforceable under 55603, it has to be an out-of-country foreign judgment that is final and conclusive and enforceable were rendered, even though an appeal therefrom is pending or subject to appeal. And then 55604 tells us that what it means to be conclusive. And what it says is it must grant or deny the recovery of a sum of money, not entitlement to it, but a sum of money. So it's only a judgment that grants a specific sum of money, as the courts have, other courts in other parts of the country have interpreted, that is subject to recognition under this Uniform Act. And I want to talk about why it is that this isn't a judgment. And certainly, when I say it's a judgment, I realize that it says that it's a judgment for some sort of fees and costs, but not for the $14 million. What happened in Brazil, and we've noted in our brief, is that the Dudas took a challenge to a $14 million arbitration award. The reason, the basis for that challenge was that both sides were asking for declaratory relief. And what the tribunal did in that case was actually, on the counterclaim for declaratory relief, awarded damages of $14 million. Under the Brazilian, they took this appeal to the Brazilian court, And the Brazilian court rejected the challenge on those grounds, but stated that the proceeding was not an enforcement action. Counsel cites to the fact that under Brazilian law, an award is self-confirming. You don't need a further judgment, as you do in this country, in order to make it, to have the force and effect of a judgment. Under Brazilian law, unlike here, the award itself is self-confirming without the need for confirmation. And if you look at the top of the page 4 of the translation, and that's page 111 of the record on appeal, you see that the Brazilian court begins by stating that there was no need for recognition or confirmation of the award, judicial confirmation of the award, because again, it was self-confirming. It does that at the very top. And again, just to quote from a portion of it, yet recognizing the existence of the obligation to pay the amount already constituted an enforceable judicial instrument in favor of the defendant, and it cites to a particular rule of law. That is very helpful to us, because it is not confirming as the sea transport case was, it's not confirming the arbitration award. It's simply ruling on the challenge that was raised by the Dudas. Because this was not an enforcement action, the purported judgment, this order, does not award a sum of money. It didn't have to, because the award itself already did that, other than these unspecified costs of the appeal. When I wrote the brief, the exchange rate for $2,283 was roughly $700 US, and that's what this judgment is awarding if we want to do the translation, which, by the way, the Bianchi case out of Illinois says we can't even do that conversion. In that case, like in this one, they were asking for the court to use just the exchange rate between Italy and the US dollar, and it said we can't even look that far. It has to be evident on the face of the judgment itself. And I want to kind of analogize it for purposes of our understanding, because we're here in Florida trying to interpret what it is that it means under Brazilian civil procedure to have this order that came out. If the trial court in this case issues a judgment in a bench trial and an appeal is taken, and this court affirms that judgment, that opinion from this court doesn't become the judgment. It doesn't have any executory effect. It is just an opinion affirming the judgment. The judgment is still a judgment upon writs of execution, writs of garnishment, and all sorts of other writs will issue. So the notion that this review by this court constituted a judgment is just flawed. Flawed for the very simple reason that it was examining a challenge to the jurisdictional authority of the arbitration tribunal. It isn't a judgment for $14 million. It is a judgment for, conceivably, the equivalent of $750 US, but we can't even do that math because the Act does not provide for that. The Act provides for what is the specific amount of the judgment. And as Your Honor said, why would we get into the background and see what it is that the Brazilian court meant when it said 15% of the value of the action and the legal fees for appeal are $2,283? So certainly not a judgment for the $14 million. But even if it was, it can't be enforced as Judge Hayes held because it doesn't award a specific sum of money. The only case that has discussed this issue in Florida thus far is the NICOR International case out of the Southern District of Florida. The foreign judgment in that case was a declaration on liability. Liability was found. It is true that there wasn't an award issued just yet, and the plaintiff in that case sought to have that enforced in Florida under the Uniform Act. And they try to use as evidence of the amount of the damages a statement of claim that had been submitted, which under the relevant local law acted almost as an admission of the amount. And the court said, we can't look at that. We can't look at that. The only thing that we can look at is the judgment itself to make a determination as to what it is that we're going to be enforcing. We can't be looking behind it because, again, that gets into very difficult questions of what the civil procedure is in a foreign jurisdiction and how the courts in that jurisdiction would rule. Judge Mara there explained that the Uniform Act does not provide for the recognition of a foreign judgment on the basis of any document other than the judgment itself. And precisely for that reason, it declined to confirm the award under the Uniform Act. So even if it was a judgment, because it doesn't specify an amount, at best it specifies an arithmetical computation based on an exchange rate, it cannot be enforced under the Uniform Act. I want to talk briefly about, and by the way, that's also the Bianchi case stands for that proposition, and the Farrow case that we've cited also stands for that proposition. Those are the cases that have interpreted the very issue before the case. I want to talk briefly about the sea transport case because that one is important. That's the main case the council relies on. In the sea transport case, there was an arbitration award issued by an arbitration tribunal in France. There was a challenge to that arbitration award in the courts of France, and there was evidence presented at the hearing like the one that we had before Judge Hayes by way of affidavit or retired judge that said under French law, and specifically, the French law is specifically cited, when you have a ruling, a review by a court of an arbitration award that declines the challenge, that operates as a writ of execution, what they call exequatur. And because of that, then, that had the force and effect of a judgment. Here we don't have that. And not only do we not have that, it's the opposite situation. And again, I come full circle to the point that I made earlier. The order itself says this is not an execution because the award itself is already executory. You don't need a confirmation order. So that's the distinction that was made. There is the application of the New York Convention under Chapter 2 of the FAA. The New York Convention is brought in. They could have brought an action to enforce it. They're having to deal with the issue that they took too long. They exceeded the statute of limitations. But there is a remedy, and it would be unwise for this court to make law in Florida based on a judgment, or an order rather, that is not a judgment for $14 million and certainly doesn't specify an amount. Unless the panel has any other questions, I thank you for your time.
Thank you.
May it please the court, I just have a few points to address arguments that opposing counsel made. With regard to the Brazilian court order, the amount of damages had already been determined. So by confirming the arbitral award, the court upheld that award amount. Now, it's true that it could have just gone forward and enforced that award, but had appellees had not sought a declaration of invalidity of the arbitration award, then the facts here would be very different, and we likely probably wouldn't be here today at all. But appellees did take that step and now must deal with the consequences of its gamble and the court's upholding of the award through dismissal. And the district court for the Northern District in Illinois, in the National Aluminum case, in that case, there was also a dismissal of an appeal, and the court held, while styled as a dismissal of an appeal, the high court judgment was clearly a decision on the merits, because the high court opinion concluded that the arbitral award was based on a correct appreciation of the facts and the law. And so, Your Honors, in sum, the case before the court is on fours with the Second District and the Northern District, Illinois, and their decisions of Sea Transport 2 and National Aluminum.
So this case didn't make a determination that it was correct on the facts and the law. This case didn't say, yeah, you're entitled to the $14 million because that's how much the contract was worth, and you paid that, and now you should get it back. What it said was the arbitrator didn't act outside its discretion in granting the award as opposed to simply declaratory relief. So it's not really the same thing as a de novo review of the facts and the law. What it is a determination of that very discrete issue.
Well, the court stated that the scope of the action was the validity of the arbitration award, and when plaintiffs challenged the validity of that for the reasons that they challenged it, the court said that, and the plaintiffs, excuse me, I mean the appellees here, that on merit the appellees were not correct, and the award decided justly on the termination of the contract and the return of the exclusivity fee, and the court had already referenced the exclusivity fee of being the $14 million. So we would respectfully request that the order denying recognition of the foreign judgment by the trial court be reversed and remanded with instructions to enter judgment recognizing the Brazilian court order. And unless the court has any other questions.
Thank you.
Thank you.
Thank you both. That concludes our session of court for today, and we are adjourned.